of the three you're going to be hearing about today, and I am going to address agricultural foreclosure issues. I was particularly pleased that I've presented on this topic this year and last year both. I only do litigation. I tend to do foreclosures quite a bit, not exclusively these days, but I have had periods that's pretty much all I was doing was larger foreclosures. And I commonly like to use the Grim Reaper as my imagery. It's very appropriate when you're in a foreclosure situation, and it's unfortunately somewhat appropriate when you're talking about agricultural foreclosures. So I thought that was the way to begin this presentation. I'm also going to confess that agricultural foreclosures are rife with specific aspects that you simply need to review the code. That is, people that do it commonly are going to have the code at their hand throughout the process, because there are a lot of specific provisions that need attention. You have to be very careful about them. And I begin with that disclosure because it's simply not the case that you're going to retain everything that I talk about today. What I'm hoping is that I can give you enough general guidance that when you're in the process and you are going through it, that you have a better understanding. Whatever lawyer you're using throughout the foreclosure process, whether it's this firm or another, will literally have the code beside them, because they need to make sure that they're attuned to these aspects. Another point that I like to point out about foreclosures from the bank or financial institution point of view is that these are equitable proceedings. That has a significance for attorneys, but what it really means from the client or the customer or the bank position is that you don't have a jury trial. And as a result of the fact you don't have a jury trial, in most instances, the court will let virtually any argument and any type of evidence in if you actually have to try the case. I think that's important for financial institutions to be aware of, because typically the arguments that the debtor will make are simply not going to carry the day. A lot of times the judge will simply want the debtor to feel as though they've had their day in court. Arguably, maybe the judge would want to avoid any kind of error by excluding information. So they're going to let everything in. And to the extent that you or your bank, your financial institution, find yourself in a foreclosure and actually trying it, don't be frustrated if you find that the judge is pretty much letting everything in. Usually that is not going to really affect the outcome of the proceeding at the end of the day. The purpose of my presentation today is to outline several special protections that borrowers have in the foreclosure process when we're talking about agricultural land as a secured property. The protections are numerous. We're going to talk about 6 today, and they really run throughout the process. Obviously, this is an example of a couple things. One might argue a strong farm lobby and how the farm lobby has maintained and been able to get these types of protections into the code. But also, I think just in general, the legislature, even if you're from a more urban or suburban location, you recognize the importance of the farm economy in Iowa, and particularly considering some very unfortunate historic periods, we want to make sure that we're giving these farmer debtors every opportunity throughout the process. So we truly are bending over backwards. From my experience in foreclosures, where there are a lot of aspects that help the borrower, the agricultural foreclosures have more protections than any other scenario that I'm familiar with. It's important to recognize in the presentation that I'm giving today that agricultural land is most commonly defined as land suitable for farming. That's the basic definition in the code, but you will find that dependent upon the code section you're relying on, there might be specific modified definitions that you'll be looking at. There are 6 different protections that we're going to talk about briefly today. I'm a little pressed for time, so again, I don't expect that anyone would be able to answer a quiz at the end, but I want you to be aware that there are notice protections, a requirement for mediation, certain preferences given in the receivership. The borrower will have an opportunity to request a continuance that other borrowers would not. The borrower will always have the right for redemption after the foreclosure, and even at the end of the process, the borrower will have a right of first refusal before there is any type of sale. So starting into the first protection for a borrower, when a lender is foreclosing on ag land, you're going to have to give the borrower a notice to cure default. because this is so prevalent and required in agricultural foreclosures, the code states a creditor shall not initiate an action to foreclose a mortgage on agricultural land unless the creditor has complied with this section. In virtually every foreclosure I have, the lender typically believes that they are required to give the notice to cure default, even if it's not required in the loan documents. And in what I'll call commercial foreclosures, foreclosures that are not for agricultural land, that is typically not required. You are not required unless your loan documents require it. There is no statutory protection. But again, because of our farm lobby or the approach we have here, you're going to have to give the borrower, the farmer borrower, the notice to cure default. And you're going to have to do it in a very particular way. But there are going to be a couple of instances where you don't have to give notice, and they're going to be very narrow. You're going to have to give that notice to cure default unless you've already given the notice with regard to 2 prior defaults, which means they've actually had 2 bites at the apple, and then this is the 3rd one. Or if you've given the notice once within the past 12 months, we're not going to require that you give the notice in this instance, or if the borrower has voluntarily surrendered possession. So in those instances, you will not have to give the notice to cure default. But in other instances, if you're dealing with agricultural foreclosure, you're going to have to give the notice. And the notice has a lot to it. The notice here has to be in writing. It is going to have conspicuously state, so you got to make sure it's going to be in a larger font or something like that that makes it clear to the borrower. Has to have the creditor name, address, telephone number, or other person to which the payment would be made. Has to have identification of the obligations secured by the mortgage. Has to explain the nature of the right to cure. Has to have a statement of the nature of the alleged default. It has to give a statement of the total payment, including an amortization of any delinquency or deferral charge. It has to state any type of other performance that might be necessary to cure the default. It has to give a cure deadline and as an exact date. And it has to include a statement that if the borrower does not cure the alleged default, the creditor or a person acting on the creditor's behalf can proceed with initiating a foreclosure action or procedure. If you do agricultural foreclosure as much as an attorney, you simply have a form or a template to make sure that you hit all these. You're going to have to, if you have any of them arguably missing or not present, you won't have given sufficient notice. And in this instance, if you have notice content that does not comply with the code, it's not going to be a claim or a defense of the claim or invalidate the foreclosure unless the borrower can argue that that failure to have that notice substantially prejudiced them. Again, in a court of equity, I think we're going to probably be a little deferential of what that means in favor of the borrower. So it certainly is better to make sure that you have a form or template and that you hit all those bases in giving your notice. We also have specific direction as to how the notice is delivered. The notice in this instance is going to be deemed received if sent by certified mail. The borrower has 45 days to cure the default after the notice is given. And the time period for a request for mediation, which we're going to talk about in a moment, also can run concurrently with this period. So you can send out your notice to cure, have that 45-day window start running, and then at the same time you can initiate the request for mediation and potentially see if that can occur in the same period. Until the expiration of the 45 days after notice is given, the borrower can cure the default. And what they do to cure is they tender either the amount of all unpaid installments without acceleration, plus a delinquency charge, which is the scheduled annual interest rate plus 5% per annum for the period between the giving of the notice of the right to cure and the tender. So there's a little bit of penalty there. Or they can then cure by paying the amount stated in the notice of right to cure, whichever is less, if it's a lesser amount, or you can tender any performance necessary other than non-payment if there's some type of default that was not a monetary default, and that which is specifically identified in the notice of right to cure. The act of curing the default restores the borrower to the borrower's rights under the obligation and the mortgage. except for it does count as the giving of a notice of right to cure for purposes of our counting exercise earlier. So they've had their first strike if they have been given the notice and they then cure in face of receipt of the notice. A borrower is not prohibited from voluntarily surrendering possession, and sending the notice does not prohibit the creditor from enforcing the interest at any time after complying with the notice requirement. So that's the first protection of the notice. The second protection given to agricultural borrowers in foreclosure is mediation. This is something that the lender must attempt. Of course, there's no guarantee of success, but you have to go through the process. And this is, again, one that most people are sort of conceptually similar with, that is only required in agricultural and only in certain instances, most of which are going to be satisfied, and that is you have to have a debt. It has to be agricultural property. It has to be subject to a debt of $20,000 or more under the mortgage. Unless you get a mediation release, then you don't have to attempt mediation. There are going to be instances where a court could determine after notice in a hearing that the delay of mediation would cause the lender irreparable harm. That's fairly unusual that you would be in that situation, but if, for example, there was something unusual about the circumstances that the lender could show irreparable harm, you could give that some consideration. And title to land that is agricultural property is not affected by the failure to receive the mediation release, regardless of its validity. There was one case I wanted to point out that I don't have in the materials that had come down from the Supreme Court in 2013, and it's relatively unusual for the Supreme Court to address agricultural foreclosure issues, so I did want to draw the audience's attention to it. There was a case called Schaefer versus Putnam Law Office, and SMP, and I was Supreme Court decision from December of 2013. It was essentially a procedural suit issue before the court, but it's something of may have some significance to the audience today, and that is in the SMP case, or the Schaefer case, what had happened was that there was a suit that was brought that was a breach of fiduciary duty suit, where the plaintiff alleged that a mortgage that had been delivered to the plaintiff was unenforceable. So they were not directly attacking the mortgage, but they were saying, you breached your fiduciary duty to me. It was actually a very convoluted factual scenario. They were actually suing former counsel that had represented them, and they were saying that the consequence of the breach of fiduciary duty was that a mortgage that SMP had obtained was unenforceable. Well, what happened then was the defendant sat back and thought, you're putting the validity of the mortgage at issue. So I have to counterclaim, and I'm going to say that the mortgage is enforceable, and I'm going to seek to enforce the mortgage through a foreclosure. They filed their counterclaim. They did not attempt mediation before doing so. And they went through the process, and ultimately the district court said that that was appropriate, that they did not need to attempt a mediation before filing the counterclaim. Of course, it goes up on appeal, or we wouldn't be talking about it. And the Court of Appeals reversed and said, well, we look at the code section that requires the attempt at mediation, and we say that anyone who desires to initiate a proceeding is required to attempt mediation, and we're saying that you're desiring to initiate this proceeding by filing your counterclaim, so we're going to say that you had to attempt a mediation. So the Court of Appeals reversed the district court. The Iowa Supreme Court took it up on further review, and the only issue they looked at, and there were several other issues that had been hashed out in addition to this, the only issue the Supreme Court looked at is whether the creditor who was bringing this counterclaim was required to attempt the mandatory mediation. The short answer for purposes of today is that you are not required to try to mediate if you're bringing what's called a compulsory counterclaim. The compulsory counterclaim here was the plaintiff was putting the validity of the mortgage into question and was saying the mortgage isn't valid and we don't have to pay because this mortgage is bad. And the bank was saying, well, wait a second, we are questioning the validity of the mortgage and we think that you're in default under the mortgage. if we don't bring this now, there could be some adverse decision made that would affect our ability to enforce the mortgage in the future. So we have a compulsory counterclaim. It's based on the same transaction or occurrence. And if there's the same transaction and occurrence underlying the concept, you're bringing a compulsory counterclaim. And if you're bringing a compulsory counterclaim, you do not have to seek mediation first. From the lender's perspective, what this means in the future is to give careful consideration if there's a suit against the lender that raises the question of the validity of the mortgage. Think long and hard as to whether suit on or a claim back again with regard to the validity of the mortgage, would that be a compulsory counterclaim or not? It's probably most prudent to go ahead and take the steps to do the mediation. That would never be problematic. But if it is not truly a compulsory counterclaim, the Schaefer authority would say that you do not have to attempt mediation in that instance, and you would be allowed to have your counterclaim proceed. The next preference or protection that we're talking about for agricultural borrowers in foreclosure are certain receivership preferences. Receivership preferences as to how the receiver is appointed, how the profits of the receiver are applied, and then at the end, the right of first refusal and how that works in light of the receiver here. All foreclosures, if you have any type of foreclosure, the owner or person in possession is given preference to lease the mortgage premises throughout the duration of the foreclosure. There's always court approval necessary for that, but that's the preference given. In agricultural foreclosures, the preference is that if a receiver is appointed, if you have agricultural land, the owner or person in possession shall be appointed as receiver without bond, provided that all parties agree to the appointment. So there's a slight preference that it's required, it shall be appointed, and there's no bond that's required in that instance, which typically there would be a requirement for receiver bond. The agricultural borrower also has additional priorities as to the application of rents or profits during the receivership. There's a statutory hierarchy as to how those costs are paid. First, the receivership costs go to the cost of the receiver, then taxes, then we have insurance, and lastly, as determined by the court, the balance is then paid as determined by the court. That's how the priorities work with the agricultural receiver. If the owner or person in possession is not afforded, let me take a step back. There are two different types of priorities given with if the owner or person in possession is not afforded right of first refusal in leasing the mortgage premises, as we talked about the priority given, the owner or person in possession has a cause of action actually against the receiver to recover either actual damages or a $1,000 penalty, which can include attorney's fees. So that's a significant deviation from the commercial context as well, because typically there is no cause of action that arises if the owner is not given the right to retain possession of the property during the receivership. Also, another priority that's given to the borrower, the receiver shall deliver notice of an offer made to the receiver to the owner or the person in actual possession, which contains the term of the offer and the address of the person making the offer. That has to be done, delivery has to be done personally with return receipt or certified or registered mail, and an offer shall be deemed to have been refused if the owner does not respond within 10 days after the offer is made. Another significant pre-foreclosure protection, the borrower is allowed to seek a continuance. The purpose of this section of the code was to allow the mortgagor the chance to refinance or to pay up the indebtedness and save the farm within the moratorium period. In all actions, when the owner enters an appearance and files an answer admitting some indebtedness, those admissions cannot be withdrawn or denied after continuance is granted. The owner can then apply for a continuance of the foreclosure action if the default is, or the inability to pay was brought about by drought or flood, heat, or other climactic condition or infestation, so something that was beyond the control of the debtor. Application has to be in writing and has to be before a final decree. So again, this is earlier in the procedure. And upon the filing, the court sets a hearing and then gives notice. If the court finds that it's made in good faith and that the finding of the drought, infestation, etc., is satisfied, then the court grants the foreclosure continued in one of two ways. If the default occurs before the first day of March of any year, causing the loss and failure of crops on the land involved in the previous year, the continuance ends on the first day of March of the succeeding year. Or if the default of the terms of the note occurs after the first day of March but during the crop year, and the year's crops fail by reason of any of the causes set out, the continuance ends on the first day of March on the second succeeding year. So those would be the two instances for the continuance. You only get one continuance except for extraordinary circumstances. Typically, it's not going to exceed a year. And the order would appoint a receiver, which is again going to have certain proceeds dictated. And one of our last limitations upon the lender, you're never going to be able to foreclose without redemption. You always have the right to redeem if you have a foreclosure of land that's used for an agricultural purpose. And agricultural purposes are specifically defined by the code, as are agricultural products. And in general, if you satisfy the agricultural purpose and the agricultural products, you're going to get a 1-year redemption that can be extended for a period up to 5 years by written agreement. Before redemption, the debtor is entitled to possession of the land, and you can't redeem if you've stayed execution. And if the lender is the winning bidder at the sale, you're going to get a certificate of purchase instead of the deed, and then after a year, you're going to change that in for the sheriff's deed. And the final protection that the borrower gets in an agricultural foreclosure is you're going to get a right of first refusal following the recording of the deed. When the deed is for agricultural land, we're going to give the right of first refusal for 1 year. The grantee records the sheriff's deed within 1 year and 60 days from the date of the sale. And within that period, we're going to give the grantee options that are not available if we don't have we're going to give the debtor options that are not available if you don't have an agricultural foreclosure. There are also additional requirements then if you have public auction or private auction, that I'm going to jump through here because I'm getting over my time. And lastly, I'm going to point out that an overlay for all of the foreclosure, you have to give borrower a 14-day demand payment of accelerated balance before you file but after the cure period, or you're not going to be able to request an application of attorney's fees. The judge will always decide if the fees are reasonable and necessary, but if you haven't given the 14-day demand, you're not going to be able to request fees in your foreclosure. So now I'm going to transfer this over to Brad Cruz, who's going to talk about certain bankruptcy aspects that pertain in the agricultural arena.
Thanks, Molly. Hi, I'm Brad Cruz, and I'm going to talk